Paul, yes. Just looking, the courts may be at odds as well over whether the due administration of justice, section 1503, may be obstructed by corrupting a witness from before a federal judicial proceeding or any other obstruction covered under 18 U.S. Code 1512 or 1513. But the Second Circuit held in 1991 that when Congress enacted the more specific witness tampering, and witness retaliation provisions of 15, 12, and 13, it intended to remove those crimes from the Omnibus Clause inventory of proscriptions. Yes, yes, yes. The Second Circuit has found it unnecessary to do so thus far. Oh, now the specific kinds of misconduct, yes, will provide the basis for prosecution under the Omnibus Clause of Section 15. Now, I know, Pope. There was the thought that you would obstruct the witness known as Heidi Lee Budnick from appearing in court. Yes. See, when you arrested me for the allegation of violating the protection order, and I had informed my public defender, Bruce Hannafy, I said, I know there's one witness that I want to call to the stand, the actual petitioner. Now, let's see. You arrest me for the allegation of a crime of violating the protection order. Yes. We go through quite a few different court hearings, and you decide that I'm going to have a mental health evaluation, Pooch. And then when I wanted to reschedule it as a witness or a defendant, because does the court violate attorney-client privilege? When somehow you found out that I called the public defender's office and wanted to reschedule my mental health evaluation. Now, when you think about my rights as the accused, is there attorney-client privilege that when I call my public defender, oh, look it! And was it Bruce that mentioned to Judge Porter right now? See, when I was not present in court and you decided you were going to request my presence in court without notice of the state of jurisdiction, and you think about my privileged communications with the public defender's office, how the fuck is it that they decided that they were going to inform you that I needed to reschedule my mental health evaluation because of blood nausea? I think there's some obstruction of justice there. You decided to have me arrested for a failure to appear in Sequim, Washington? Yes. I kept telling you that I was not given any notice or opportunity to be heard. And for some reason, I could not communicate with my public defender without you violating my privilege. Then you had a mental health evaluation when I was in jail for 27 days. And you found that I wasn't competent to stand trial, and that went on my background check so that any future employer that I might have would say that I'm a crazy